actually the victim of it. So they broke into my house. They assaulted me, stabbed my husband. The baby was a month old when they broke into our home. They knew that, and they still chose to break into our home. She still came in with Wilson. When Wilson moved and lunged for him, she still lunged for him as well. She assaulted me.
Can you pause for one moment? The baby, are you talking about her baby?
Yep, he was a month old when this happened.
And he was in the back seat of the car when they came and did this.
This is case number 26CR43430, State of Ohio versus Tia Spradlin. Ms. Spradlin is present with her attorney, Josh Engel. The state is represented by Brian Goodyear. First, we're set for a pretrial. We've had some discussions in chambers. My understanding is this may be a trial to the court, and it may be combined with another defendant who I assume is Ms. Spradlin's husband. Is that correct?
That is, Your Honor, yes.
Okay. Ms. Spradlin is also requesting a modification of bond. And my understanding is the victims are here. Is that correct, Mr. Goodyear?
That's correct, Judge. Both victims are present.
Okay. How do you want to proceed? Do you want to go ahead and state your basis to modify bond, then give the victims a chance to be heard? Is that a good way to do it?
That makes sense.
Fine with you? Okay, go ahead.
Your Honor, in terms of bond, and I think the defendant probably would like to address the court as well on this. I think it would probably be helpful to hear from her. A couple things I would simply say. I think, as Your Honor heard about the facts of the case, this is a he said, she said case, essentially. I think what it will come down to. You have before you a defendant who has no felony record before, just some misdemeanors, who has got no history of violence at all. And I think it would be appropriate to have her on an OR bond with electronic monitoring and no contact order, or perhaps a curfew in that situation. And I say this for a couple reasons. In addition to the history I talked about, she has an 8-month-old child that she cares for and has doctor's appointments and various things that the child needs, and she would take care of that. That's certainly in terms of bond issues, makes her not a flight risk. She's got lots of ties to the community. She has her mother here as well, who can speak to these issues.
Okay.
She also has, I want to say, she also has a job that she would like to work, and so you know, she's not someone who is not a productive member of society. She wants to go work that job. So I know she probably wants to address the court as well.
Yes, I just want the chance to get out and work and take care of my baby, get him to his doctor's appointments and things. My mom's here. I stay with her. I turned myself in as soon as I found out that I was wanted. So I hope you're here.
Okay, thank you.
And my baby right now is really sick. He's got an upper respiratory infection and an earache.
How old is your baby?
8 months old.
Okay. Anything else you want to say?
No, sir.
Okay.
No. As I said, we're asking for an OR bond with electronic bond.
Okay, thank you. Mr. Goodyear, anything from the state?
Well, first, I would like, if the victims would like to speak to the court, I'd let them go first.
Yeah, please come up to the podium.
My name is Caitlin Hall. I am actually the victim of it. So they broke into my house. They assaulted me, stabbed my husband. The baby was a month old when they broke into our home. They knew that, and they still chose to break into our home. She still came in with Wilson. When Wilson moved and lunged for him, she still lunged for him as well. She assaulted me.
Can you pause for one moment? The baby, are you talking about her baby?
Yep, he was a month old when this happened.
When this
And he was in
happened?
the back seat of the car when they came and did this.
Okay, and who's Wilson?
Wilson is her husband who came
Okay.
in and stabbed him with her.
Judge
Okay.
Wilson Rivera is the co-defendant.
Okay, very good. I've not even touched that case
It's
yet.
also the baby's father.
Okay. I've got it now. Go ahead now. Sarah, you'll have a chance to speak in a moment. Go
But
ahead.
I mean, as for that, after they broke into our home, they lunged for us the way they did. As soon as they came in with a knife ready to kill us. I would rather them stay on the bond that they have. I'd rather them stay in jail because I still, to this day, I can't sleep right at night. I'm scared that someone in their family is still going to break into our home and still going to finish the job that they came in to do in the first place. I feel like if they cared about the child, she would have stayed at home taking care of the child when he was first born. Having him be a month old when she still chose to break in the house, that proves she didn't care about the child at the time. That's how I see it. Because I wouldn't be standing here like this. I have 4 kids as well. I'm not trying to keep a mother from her children, but I'm trying to keep somebody from hurting me and my family anymore.
Okay, and keep in mind, I know nothing about this case until I just spoke with the attorneys a minute ago. How do you know these people?
I used to work at Rally's. That's where I met Tia when she was pregnant. We ended up becoming friends from there. I tried to help her with doctor's appointments during the baby's prenatal care. I'm the one who took her to deliver the baby. That's how I know Tia.
And did they live with you?
They stayed a couple weeks, but they came and gone, so they went back and forth to her mom's house. They did not actually live with me, no.
Okay. When you say they stayed a couple of weeks, did they stay overnight?
Yeah, they stayed overnight, but then they would take and leave. So they never kept all their stuff there. They always had most of their stuff at their mom's.
Okay.
And they just come and go.
Okay, I just have a better picture. I'm not trying to turn this into a trial. I just
Right.
want to hear why you want her to stay in jail.
Yeah, I want her to stay there so I don't have to worry about my family being hurt anymore. I mean, he was stabbed clear in his head all the way across. He was bleeding everywhere. I just don't want to be stabbed or killed again almost.
Okay, thank you.
Thank you.
Sir, you have an opportunity to be heard.
My name's Jesse Etzel. I'm concerned for the child because, I mean, they had a little baby in the back seat of their car when they brought Tia and Wilson to commit this crime. I'm not sure who was driving the vehicle, but I'm just concerned for the child, really, because it was in the back seat of the vehicle. Why would they bring that baby with them to commit the crime? I had to get stitches from here to here because of what he has done. But that's all I wanted to say.
Okay.
Thank you, Your Honor.
All right, thank you. Mr. Goodyear,
Judge, in addition to what the victims had to say, while Ms. Spradlin may not have any prior felonies, she does not have a clean record. Between 2014 and 2023, she has 7 theft convictions. She has been charged with, and I don't know what the outcome, in 2018 she was charged with endangering children, but there was a capious order that, at least as of the time this was prepared, it had not been resolved, I guess. So she has a consistent history of contacting the court system for a variety of different types of offenses. Judge, I think that the bond that was set with all this information appropriately, and we'd actually maintain the bond.
okay, thank you. Any, what I'll call rebuttal, Mr. Engel?
Other than, I think, as the court realized, this is not the forum to try the case, and a lot of the facts that were asserted here, I think, would be disputed at trial, which is a reason to say I think this bond may have assumed a lot of facts and seem that are not likely to be shown at trial.
Okay. Well, they clearly know where the victims live, so I don't know that. Where do the victims live?
You want me to give their address?
Yes.
Okay.
It's like a 9-minute drive.
It's like 10 minutes from her mom's house.
So just tell me what your address
668.
6880 Brandywine Street. It's the Middletown part.
Okay, this is a Middletown address?
Yeah, Middletown. It's a Middletown portion of Warren County, Judge.
That's basically what
Yes,
I was
yep,
looking for.
yep.
I was trying to see, where does your client plan to reside?
904 Catalpa Drive, Middletown, Ohio.
Middletown also, and that's close to the victims in the case?
Well, they live like towards Walmart. It's not close. It's not walking distance.
Okay. All right, I'm going to modify the bond. Should be given an OR bond. I don't really see, I haven't seen anything that would cause me to believe they're going to go back. So if
Your
you,
Honor, after this was all, when he got arrested the first time and the guys got hacked and stuff and they got out, he was sitting at my house inside of a red vehicle late at night. I called the cops on him. So, I mean, they get out. He will definitely come back. I ain't sure about her.
He messaged me to try to meet up with him.
Yeah. I'm sorry, but you'll be making a mistake if you are hurt today.
okay, I'm granting an OR bond and place her on a monitor. She'll have a curfew. The main purpose of the monitor is that we will know where you are, and that works both ways. It works both ways. If someone says you were here, we'll know whether that's true or not simply by the GPS.
Okay.
In the meantime, just can't have any contact with the victims. You can't go on their property. I don't know if they live in an apartment, then you can't go on the apartment property. In other words, you or your husband
Yeah.
cannot go and park in the parking lot of that apartment complex. The purpose is, I'm not saying you've done any of this. The purpose, though, is to keep you guys apart. And it sounds like that's what everybody wants. So that's the new bond in the case. Anything else from the state?
No, Your Honor, thank you.
Your Honor,
Mr. Ing-
would the court waive fees for the monitor? She hasn't been working for a while.
If she's indigent, I will at the end of the case when costs are assessed.
Yes, sir.
But we'll waive any kind of installation fee that she would have to pay up front. We're going to get is this going to be a jury trial or a bench trial?
It will be a bench trial, Your Honor. We've executed a waiver.
Okay.
What I would recommend, Your Honor, is we wait to set this until the co-defendant comes in tomorrow, and set these both at the same time, as long
Okay.
as everyone's okay. I think the prosecution's okay with that, as long as Mr. McKenna's okay with that. That seems to make sense.
Why don't
And
you
Judge, that's correct. I mean, certainly knowing that these two defendants are alleged to have engaged in conduct in concert, certainly would be appropriate to join the cases for trial. Now knowing that both individuals want to have a trial, and it's my expectation from speaking with counsel for Mr. Rivera that he also wants to have a bench trial, then I would ask the court to simply wait for his pretrial tomorrow so we can set this at a time that works for all parties.
Josh, can you give Bethany some dates that you're available just so it'll be helpful to her tomorrow?
Yeah.
Melissa, you have a very important job here in this matter. So there's probably going to be a lot of communication back and forth. So we'll set it for a bench trial. Ms. Spradlin,
Yes.
I have a document entitled jury waiver here. You're charged with a criminal offense. You have a right to have a trial by a judge, who would be me, or a jury of 12 people. If before you could be convicted by a jury, all 12 of those people would have to agree you had been proven guilty beyond a reasonable doubt. In other words, the verdict would have to be unanimous. If you try it to the judge makes the decision. Is it your desire to waive the jury trial and proceed to a trial before the judge?
Yes.
Okay, I accept your waiver. We'll get this set as soon as possible.
Thank you, Judge.
Thank you both.
Thank you.
Under Ohio Criminal Rule 46, the court is required to determine conditions of release that reasonably assure both the defendant's appearance in court and the safety of the community and alleged victims. The court may impose a personal recognizance bond, along with restrictive conditions such as electronic monitoring, curfew, and no-contact orders, when appropriate under the circumstances. In this matter before the Court of Common Pleas, State of Ohio, the defendant moved for a modification of bond, which the court evaluated in light of statutory and rule-based factors, including the defendant's criminal history, ties to the community, risk of flight, and the nature of the alleged offenses. The court also considered victim impact statements, particularly regarding ongoing safety concerns. Balancing these considerations, the court granted a modified release on an own recognizance bond, subject to GPS monitoring, curfew restrictions, and a strict prohibition on any contact with the alleged victims or their residents. These conditions are enforceable, and any violation may result in revocation of bond and redetention. Additionally, pursuant to Ohio Criminal Rule 23, the defendant executed a knowing and voluntary waiver of the right to a jury trial, electing instead to proceed with a bench trial. The matter is to be scheduled for trial, potentially joined with a co-defendant, with all issues of fact and credibility reserved for adjudication at trial.